Adjournment requests, if any.
May I please Lordship, the concern under side, I'll mention item number 5, your Lordship.
You?
I'm paying for adjournment of the item for item number 5, your Lordship.
Why?
Senior counsel out of station, your Lordship.
Governed by that judgment, Bajaj Auto.
No, Lordship, this is another central excise appeal.
Yeah,
Item number 5. Panprag.
Please find.
it is governed by that Bajaj Auto.
No, Lordship, probably not. Because here,
Because the excise additional duty also seems to be excise duty.
that Lordship,
There were two judgments of the Supreme Court.
I'll examine.
Examine there. On the very first day, this objection was raised.
No, Lordship,
When the question of law was were framed,
on last
on
occasion,
that day also, this
no, Lordship,
objection was raised.
thereafter they admitted that appeal can be admitted. Then appeal was admitted. And
It was
Lordship,
admitted, but they relied upon that Bajaj Auto.
no, Lordship, probably subsequently, my learned senior friend has considered that this will not covered by that judge.
That is altogether different because first objection was regarding maintenance.
Maintainability.
That it will not maintainable under section 35. Thereafter, that Motorola judgment came
Yes, Lordship.
and
That appeal is.
said, "Okay, now it is maintainable." But the issue involved is covered next week.
Next, your Lordship. Obligation.
Yes.
Any other requests?
Wait, please, your Lordship.
Lord, on 7th, that Mizoram service matter was fixed.
7.
On 7th, my lord. 7th, there was a holiday. Can I pray, my lord? There's some urgency tomorrow, my lord.
Not tomorrow. Any other day. In the next week.
Yeah. That is on 13th, my lord. Yes. Diploma. One idea.
Lordship, we have filed a writ petition against the order of the tribunal, and that is pending. In the meantime, Lordship, the contempt has been filed there, and the tribunal speaks on 26, Lordship, any date before that.
Get the registry.
No stay, since there is no stay order, Lordship.
Huh?
Since there is no stay order,
Ask the registry will give you the date. If the matter is already fixed and not listed, then
no,
certainly
on last
we can
petition,
ask.
matter could not be taken up because service was not complete. Now,
Ask the
service is
registry will give you the dates. Show the dates. What's the problem?
Item number 1 for orders.
My lord, they have issued the appointment order on the last that your lordship has seen. They ought to have been posted in the school from where they have been terminated because but leaving aside, leaving aside that, my lord, two of the person at my lord serial number 3 and 10, they went to join in the school. There is already some other persons occupying that post.
Post them some other place at vacant place.
If Lordship has the second page, my lord. Of the,
3, 6 and serial number 10.
serial number 2, Lordship would find that he had retired in 2022. He pursues the matter.
Leave that.
My lord,
But read,
yes,
whatever
as
the
mentioned,
benefits
that is what we are doing it.
Okay.
3, my lord, is shown joined on 3/5. 6, he joined on 3/5 at the Gondia MES. And 10, he joined in the office of the BO because some other person was
No,
already on that post.
This 3 number, he has joined there.
Yes, my lord.
He
Joining letter
had
is
joined, but the post where he went to join, that is occupied by somebody. The headmaster has given a certificate.
This 3 number
3
He
and,
is
and 10.
and 10.
Nuno Canto.
And 6 also, my lord, the certificate is there, but we are still awaiting further instruction in regard to 6, 3, 6 and 10.
3, 6 and 10.
Yes.
These posts were already.
The others have joined in the,
Somebody else is occupying that.
yes.
Yes.
Joining letters, my lord, I have.
Yes,
next.
joining is at the DO's office.
No, joining is
Well,
for 3 and 6, the joining is in the schools.
Uh,
10 is in the BO office because someone else is already there.
What are
10 we admit, and we have also written that we will change the place of posting.
What about 3 and 6?
My lord, they have given the
Yeah,
joining
something
letters.
is
That is what they have
Huh?
given. Nuno Canto.
Wait a second. যোগদান কৰিবলৈ দিয়া শিমলুগুৰিৰ মিচিং মধ্য ইংৰাজী বিদ্যালয়ৰ অৱসৰ শিক্ষক শ্ৰী অজুত গোপী সন্দীপৰ পদটি বৰ্তমান খালী হৈ থকা নাই।
Dunakant, the lordship will find in the fourth page. সন্মান
Headmaster has
সহকাৰে
given us a-
জনাও যে অফিচ অফ দ্য ডাইৰেক্টৰ অফ এলিমেণ্টাৰী এডুকেশ্যন নিৰ্দেশ মৰ্মে মই শ্ৰী দুনকান্ত শইকীয়া আজি ইমান তাৰিখে 9 বজাত যোগদান কৰো সেই মহোদয়ৰ ওচৰত
Then this
my letter says that he has joined in the school.
you should join in the office.
In the school.
When you went to join in the headmaster has given this certificate that there is no vacant post.
If he's not, if that post is not vacant, I'll find it out.
Your lordship, list it after 1 week. Let them do the formalities, otherwise they will not do it. They have said that we will not give you the. We have to again come.
Still, if they will not do it, then what else they will do? They'll do it now.
But from 2018, your lordship.
Pursuant to the direction given by this court. The council appearing for the state has produced a letter on order dated 3/5/2025 issued by the office of the district elementary education officer Lakhimpur, North Lakhimpur,
You're too busy in your own world.
stating that all the 10 appellants, out of the 10 appellants, 9 have been posted in the MBS/MES schools of district North Lakhimpur, and they have also joined in the place of posting on 3/5/2025. Stop. In respect of one of the petitioner,
Well, not
Nandeshwar
Well, not 1-3.
Pachani, just a minute, please.
Yes, ma'am. Yes, madam.
Wait for an order. Don't interrupt. Daneshwar Pachani. It is stated that the said person has already attained the
Yes,
age of
petition has-
superannuation on 1/3/2020.
And therefore,
Posting could not be given to him.
ये वाला
It is submitted that the
धंधेश्वर प्रसाद पिटिशन है और नहीं आपको भी समझ नहीं आता है.
said petitioner will get
You
all
listen to
the
my query. I am getting to school.
service benefits as directed by this court. Why the order dated
You listen to the report.
10/7/2018 passed in with appeal number 304/2014. Full stop. At this stage, learned counsel appearing for the petitioner has submitted that out of the 10 petitioners, 3 petitioners, namely
Duno cantos है क्या?
Durna Gato Sekia, Tulani Tel, and Rajen Datta are concerned, though they have been given posting in the schools, but as there are no vacant posts in those schools, and therefore they were asked by the concerned headmasters to join in the BEEO office till the new posting is given to them. Full stop. Learned counsel, Mr. Majumdar, the learned counsel for the respondent, Mr. Majumdar, assured this court that so far as regarding the above named 3 petitioners are concerned, they will be granted posting in the
I took order कितने दिन में करना था compliance target देखो time.
different schools on,
देखो.
in the separate schools, in the schools
अरे क्या समझ रहे हो?
on the vacant posts, in the concerned schools on the vacant posts,
You have no notes.
within a period of
10 days, madam.
not 10 days, within a period of 1 week from today, full stop. This contempt petition on 15th,
On
15th May.
The 16th, my lord.
15th.
Published.
My lord, your lordship has said that Dandeswar Pachani is one of the petitioner. He is not the petitioner. He is not before your lordship.
So 9 petitioners are there only. How many
Yes.
petitioners are there?
8.
8. And another is, who is the another person who is not the petitioner out of these 10?
I'll just check, my lord. 8 are there out of 10.
Clarify 8, we'll clarify now.
My lord,
Clarify 8 now,
Yes,
let's clarify.
go for it.
কানেশ্বৰ দলে আছে জ্যোতি বৰুৱা যোগানন্দ বৰগোহাঁই ৰাজেন দত্ত কান্তেশ্বৰ গগৈ দ্ৰোণকান্ত শইকীয়া তুলনী তাই
Lohit Somua,
Huh.
Lohit Somua and Dandeswar Patasani are not before your lordship. Serial number 2 and 5. Since they are beneficiary of the earlier orders.
They are confined to the petitioners only.
Yes, yes.
Okay. Let me consider for the. Let me consider for the respondent has submitted that. All the 8 petitioners of the contempt petition has been posted in the different, in the schools falling under the jurisdiction of the district elementary education officer Lakhimpur, not Lakhimpur. Full stop. An order dated 3/5/2025
This will be able to make a
issued
note.
by, issued by the office of the district elementary education officer Lakhimpur, not Lakhimpur, is produced.
Same as I have looked, but
It is placed on record. Is produced which is placed on record. Full stop. Learned counsel for the petitioner has submitted that 3 persons का नाम आ जाएगा. Duran K. Sekia and this Tulani Ted and Rajen Datta, though have been provided posting in the different schools under the jurisdiction of the district elementary education officer Lakhimpur, not Lakhimpur, but the posts on which they have been posted are already occupied by some other employee, and therefore they were asked to join in the BO office, in the concerned BO office. Full stop. At this stage, when a counsel appearing for Mr. Al Majumdar, when counsel for the respondent has submitted that the above named 3 persons will be granted new post, will be posted in the
division bench का order निकाला था जो
concerned schools where the
expand content है.
posts are vacant within a period of 1 week. Full stop. In view of the submission made by the learned counsel appearing for the respondent, place this matter on 15th May. 15th May se prior to that you place that.
Published.
item 2, 3 and 4
But in regard to the other direction also, they have not taken steps, but
Will
from
see-
2000, yes, yes.
Malas, we are a tea state who is manufacturing tea and using coal as fuel. Malas, what had happened in 2010, the government has imposed,
Come to the question of law frame.
my lord,
Question of laws. frame.
my lord, question of law was framed on 10/5/19, my lord. First is whether the liability of payment of central excise duty on coal can be passed on the purchaser, who is a consumer of coal and not a manufacturer of coal,
Whether the liability for payment of central excise duty
my lord.
is what you have mentioned, coal energy cess is not there in the question.
My lord,
This was not framed.
my lord.
Excise, it can be passed, or even though if we assume that it is also a question of law and we can reframe it.
My lord.
But where is the liability for payment of this clean energy cess was fastened upon you?
It is not upon me, it is upon the producer, my lord. That's,
That's
yes, yes.
So how this question is regularized then?
Because my lord,
Whether the liability for payment of central excise on coal can be passed on the purchaser who is consumer of the coal, not a manufacturer of coal?
my lord,
Certainly not.
no, certainly not.
And they have not fastened this liability upon you.
My lord, they have first and liability, my lord.
Not, sir.
No.
Come to the Commissioner Appeals Order.
No, वो तो commissioner वाला जो है ना.
Commissioner Order which you have filed now.
My lord.
Page number 84, annexure B.
Yes, my lord.
Now, page number 95, para number 7.
I find that this one, my lord.
Para number 7, page 95.
My lord. The adjudicatory authority has confiscated the coal and since the seized
Has
coal.
confiscated the seized coal, and since the seized coal was released provisionally, imposed fine equal to the security deposit lying with the department under section 34 of the CA of 1944, and ordered that the appropriation of the same may also be imposed penalty on the appellant under rule in terms of rule 27 of the CFR rules. The adjudicating authority has not demanded CED or cess from the buyer, since the buyer is not supposed to pay the duty and cess.
Regarding confiscation of the coal seized of the appellant, I find there is no dispute regarding the non-payment of the cess. The appellant.
Cess of seized coal. The appellant from whom the possession of the coal was seized fallen under the failed to produce duty document and so and so and so and so.
Further, the appellant is the manufacturer of the as well as conversion with the goods purchased by them are accessible goods, but grievances is also liable. As such, it was the prima facie duty and responsibility of the appellant to ask for the duty paying document since an invoice from the seller from whose receiving goods with the appellant failed to discharge the duty. Because my lord, what has happened, they
They ultimately come to the operative portion of the order.
my lord,
In view of the above, the order of adjudicating a trade for consumer so and so appropriation of the equal amount security lying with the department is justified.
just
That is only, he has simply said that the confiscation or duty equivalent to it is justified. Otherwise, all whatever the cess and 1,82,000 or something, that has already been, they have allowed your claim.
my security deposit is still lying with the department, my lord. But why?
Security deposit is altogether different thing. You
But
just-
why, my lord? Because I am a consumer. My lord, what has happened? Suppose I buy a excisable commodity.
We have to go by the, this question of law.
We can reframe it, my lord. That is,
What question of law now you are supposed to?
no, my lord. Suppose I purchase one excisable commodity, suppose a mobile. Now the excise department comes up that Mr. So-and-so, I just want to know whether excise has been paid. Now, my lord, how do I have knowledge whether excise has been paid in that?
Certainly not.
Certainly, Lord. That is what Supreme Court has also indicated.
So that's why only they have not levied this custom duty and cess, this cess upon you.
Then what
That
about
has
the
been quashed.
security deposit, my lord, that has been lying?
Security deposit against what?
And is the confiscation. That confiscation itself is wrong. Why?
Where is the question of confiscation in this appeal, sir? Please
My lord.
show us.
That is not there, my lord. That can be absolutely reframed. But what is the
Earlier, I don't find this appeals. The orders which you have under challenge, now come to your, this appeal. Come to your appeal. Prayer. Final order number so and so passed by this estate in appeal number so and so 11/8/2017. Now come to 11/8/2017. And the second prayer order in appeal passed by the appellate commissioner Guwahati on 16/9/2014. Where is that 16/9/2014? The appeal The CEST has decided appeal against the order passed on 8/3/2016. In all the three appeals, this type of defects are there. You are praying something else. Whereas the judgment against you are altogether different. What are the question of law framed by this court, sir? How these are the question of law?
My lord, I may be given one opportunity, I'll correct this, my lord, and I'll come back, madam. One last opportunity may be given.
Show us any ground in your appeal that section 34 proceedings can't be initiated against you. Show us any ground.
My lord, as far as coal is concerned, my lord,
These are the facts, but sir, where are the grounds? Such a casual manner, how can you file this? Central excise.
My lord, I will permitted to file an affidavit, my lord.
What affidavit, sir? What affidavit now? The appeal you file, read whole appeal. Where is your ground?
My lord, may come
That
to,
the proceedings can't be initiated against you under section 34. The tribunal has simply said, assess the, whatever the penalty which can be imposed upon you under section 34. This is what the tribunal has said. Accordingly, the following same ratio, the impugned order is modified so far as the penalty is set aside and the adjudicating authority is directed to assess the fine in lieu of confiscation under section 34 of the Act of 1944.
my lord, how far confiscation is also perverse, my lord, because since no due,
Where is the foundation?
my lord, may come to page 13, my lord, para
Yes.
H. The levy of cess on coal in addition to the cess or duty on the goods specified in the 10th schedule under any other law for time being it was provided under subsection 5 of 83 of the Finance Act. Excise duty is leviable under the Central Tariff Act on coal under the main heading so and so. Such excise on clean energy is leviable is liable to be paid by the producer of the coal.
Yeah.
And the tribunal will have failed to take into account.
The tribunal has taken into account this specifically
My lord,
and has recorded a finding that no, he is not entitled to, the purchase is not entitled to pay the excise duty and cess.
What
This is
about-
what the finding of the tribunal.
my lord, what about the confiscation and the
The
amount?
confiscation, where is the ground? What is your ground to challenge that confiscation? Okay,
Lordship.
if he is not entitled for this payment of excise duty and cess,
That has been already been interpreted, that has been set aside by the appellate.
that has been set aside, then how the penalty can be fastened upon?
What's it, the reasoning has been given by the tribe,
Huh?
appellate, what has given the
What is
Now-
the reason?
paragraph 11.
The appellate authority has said he was not supposed to know
Yes.
whether the duty was paid by him or not, paid by the manufacturer or not. And he was not supposed to know. How you can find him that the coal which you have purchased is not, the duty on that, the same has not been paid?
Appellate authority in paragraph 11, the appellant is also liable to pay penalty of 5,000. Rule 27 of CER 2002. The appellant is also liable.
How?
But explanation is not given.
Hmm?
Explanation is not given here.
You have to justify that, sir.
My lord, and in similar set of questions also, my lord. One, the same court, this
Sir,
step,
what do you mean by same court? Here the question of law,
Right.
you have, there is no foundation for framing the question of law, sir.
my lord.
What type of appeals do you have filed here? In such casual manner?
I'm sorry.
When the counsel for the appellants raise some time to suitably amend these excise appeals. Because this court finds that in the present excise appeal, the orders which are under challenge are not the orders by which the appellants are aggrieved. Stop. After 4 weeks.
Item 6.
According to your petition which you have filed before the court, sir. One more petition regarding your absorption in the corporation from the transport department.
No, I have not had it.
You have mentioned in the petition itself.
No.
In paragraph 16, it is mentioned.
Oh, yes, yes. So that has been disposed of.
What happened in that?
The action was set aside. That action was set aside. Lord.
Where is that order?
Already is not including that.
So now you are employee of
Yes.
employee of whom?
Some
Employee of whom?
inland water transport corporation.
Indian Water Transport. You were your services were
Corporation for.
you were absorbed in the this corporation or whatever it may be.
Yes.
What's the name of that? Inland Water
Inland water transport corporation.
Transport Corporation.
Hmm.
Your
Inland
services,
water transport.
you were earlier working in the transport department.
No, still I am working in the transport department. At one point of time, this notification was issued and we assailed this notification and this honorable court passed an order in our department.
So now you are employee of which department?
Yes, I'm transport department.
Transport department. How you are agreed by this then? If you are employee of the transport department, how you are agreed?
That so far section 14(2)(k) is concerned.
Yeah.
Two things in blood, this act operates in the concurrent list blood. This act operates in the concurrent list.
This act?
So far this act is concerned, it is operates in the concurrent list, list 3. And there is another act. That act is also operates in the concurrent list. And
Where?
both these acts are operating
On different subjects.
on the same subject. And
No,
both
different
this corporation is operating in two national waterways.
Okay.
Brahmaputra waterways and the Barak Valley waterways.
Regulatory Act 1988. Sorry, this Assam Inland Water Transport Regulatory Authority Act 2018.
That is page 13, right?
How you are aggrieved, sir? What is your grievance?
My basic grievance is lies on 14(2)(k),
How?
because,
It's a private partnership.
yes,
So how you are concerned?
because
Not
my
that-
service may be converted to the private enterprises.
Where is that, sir? How it can be converted into that, sir? 14(2) says what?
14(1)(k).
Promote public-private partnerships, private participation and outsourcing of written implementation of this act. How you are aggrieved by this?
14(k). So far as my act is concerned, is at page 14(k) to what page was it? Right. Promote public-private partnership, private participation and outsourcing for effecting implementation of this act.
Yes, how you are going to affect, sir?
Because they, at any moment, they may advise for promoting this.
It's altogether hypothetical question, sir. A situation
But
which you are
because whether
visualizing
they
is
have the-
altogether hypothetical. Your grievance regarding your absorption in the
No, I am
corporation
working.
was redressed. Was redressed. How you are concerned with this? This is the main function of the authority, the regulatory authority, to promote this. What's wrong in that? The regulatory shall of following functions as per the provisional rules framed thereunder. Promote public-private partnerships, private participation and outsourcing of the effective implementation of this act. How you are agreed, sir?
Let me come some time. I'm just the Assam Inland Water Transport Regulatory Authority is at page 13. Now, section 3 of this empowers to create a regulatory authority to be called as Assam Inland Water Transport Regulatory Authority. No problem. Okay. Aforesaid enactment is under entry 3 of 32 to a concurrent list. There is an admitted position. Now, Lord, through the same entry of this list, Parliament enacted an enactment called as Inland Water Transport Authority Act 1985.
Right.
This is also an admitted position. Now, both the Central Act and state have been authorized to create a regulatory authority.
Right.
This is also admitted position. These two created authorities are operating River Brahmaputra River. So all these things are admitted position. Now, my question is that you can create an authority, no problem. It is a matter of concurrent list. For that purpose, presidential assent is required.
If there is any repugnancy between them.
Yes, it is.
Where is the repugnancy?
Yes, that is the basic question.
Now-
What is the repugnancy?
Come to section 61 of the.
Yes,
Act
I have
of
gone through that.
2018. Come to 61.
Yes, 61. Repugnancy I will solve later. In addition to,
First of all, you put, read section 61.
the provisions of this act shall be in addition to, not in derogation of, the provisions in any other law for the time being in force relating to inland waterways, forest, wildlife, etc., etc. The functions of the regulatory are to be enabled by the conjunction with the Inland Vessels Act 1917, Indian Ports Act 1918, and Inland Water Authorities Act 1985. Yes, that is their declaration through section 16. Now, your lordship come to 14 of both this act. Now, first, your lordship come 14 of the Assam Act,
Yes. Page 21.
page 21. And you also has to compare it with the page 37 or 35. 39. Now look, page 21. The regulatory authority shall perform the following functions as per the provisions of this act and rules framed thereunder. To regulate the activities of Inland Water Transport Corporation. Hmm,
Where you are reading?
Page 21, Lord, so far Assam Act is concerned.
Yes,
And
to
A
regulate the activities of inland water transport operators.
operators.
Yes,
To regulate the activities of inland water port terminal service operators and to register vessel operators, issue licenses, certificates, permits, approvals, and maintain central database as prescribed. Now, Your Lordship, just come to page 39. Hmm. To provide, yes, just 14.1 to subclause B.
Yeah.
To provide permit setting up infrastructural facilities, national waterways. Now, both these are operating in the national waterways. So, far Assam Regulatory Act is concerned,
fine. This is what the repugnancy?
both these are operating in the national ways. Your Lordship come to clause K
Clause K of what?
of the Central Act.
Fine.
Now, so far the Central Inland Water Transport is concerned, they were authorized to enter into venture contracting relationship by way of equity participation.
Enter into joint ventures
Joint venture.
concerning inland shipping by way of equity participation.
So far the Central is concerned.
Fine.
But that power is not vested with this Assam Regulatory Authority.
Where is that? Which
Yes.
is that power?
14K.
Yeah.
Promote page 22.
Yeah.
Promote public party partnership, private participation outstanding for effecting implementation of this act.
So where is that entering into joint venture? Where is that? They can't enter into joint venture with anybody.
So far regulatory authority is concerned.
Where is the entering into a joint venture?
Then why this provision was there, Lord?
The provision they can promote. What's the problem in that? They can promote the activities without entering into it. They can frame a policy for that or whatever it may be. What's the problem in that?
Well, this promotion will be carried out in the national highway, national waterways.
Promotion. Not here they say enter into joint venture concerning land, inland shipping by way of equity participation. Where is that, sir?
That is there.
They can't enter into it. There is no such provision in this Act of 2018. The regulatory authority is not authorized to enter into joint ventures or something else, whatever it may be.
This much observation is there.
Observation, where is the need of observation? You have to satisfy, yes, sir. Specific repugnancy, you
Yes.
pointed out any specific repugnancy in the act. Simply said it is repugnant, repugnant, repugnant. How it is repugnant? How it is contrary to the Act of 1985?
So far clause B is concerned, Lord.
Which clause B, sir?
14 clause B, granting of permission, license, etc. in the national highway. Apparently, it is repugnant. This power has been vested in the Central Inland Water Transport Authority.
Where is that power, sir?
Clause 14.
Yeah.
C, to register vessel apart issues license, certificates, permits.
Clause C, where is, clause C of
Assam Act.
Assam
14.
Act, yes?
Hmm. To
Register vessels operated so and so based on prescribed.
Hmm.
And in the
Certificate,
act of-
permits, approvals, maintain central database. To grant a permission is with them.
So where is the, this power was with the regulatory authority constituted under Act of 85?
85, yes, period. Clause 14B, 1B,
Yeah,
provide permits setting up of infrastructure facilities, national waterways.
different, that is altogether different.
Because they are
Infrastructure
national.
facilities and registering a vessel is altogether different thing.
No. So far Assam Act is concerned, they are also operating in the river Brahmaputra and river, there is
Maybe,
national
but-
highway. And
But on different subjects.
no. So far Assam is concerned, they are operating in two waterways, national water. One is the river
Barak.
Barak. And this Central Inland Water Transport Authority is also operating in river Brahmaputra and Barak.
We
Now,
understand. So you are saying that in, on the two waterways, two acts can be operated. This is
Yes.
what they are, since
Two
they are contrary
national-
to each other, or they are overlapping. Where is this overlap?
overlap, your lordship will come to entry.
And it
And
is there. In the
And-
concurrent list, both of them can, enact the laws
yes,
as per the concurrent list.
yes,
But the condition is that the state law should not be repugnant to the central law.
yes.
Now you have to demonstrate where is the, this repugnancy in between two laws. Where is that?
Because both these authorities have been conferred with the same power.
Which are those same powers you just show us? That's what we are asking, sir.
To provide permits, setting up infrastructure facilities, national ways,
Infrastructure facilities. to
not in, sir, provide permit. Setting up of,
Permits are not permit. Permits means allow them to setting up of infrastructure facilities. Here the registered vessel operators issue licenses, certificates. This is altogether different things. Permitting, creating infrastructure facilities is different from registering vessels or granting licenses. Can't be the same thing.
then your lordship. So this is the basic point that I would like to play before your lordship.
That is not the at all point here.
And second thing is that whether this regulatory authority has been vested with the power to carry their business.
No, no.
If they do not carry their business, then how this section 14(2)(k) will apply to them? Because
They simply they have to make a policy for that. Even though for that purpose, they are not required to own any vessel or something else, to own any vessel.
these are the 2 points here that I will.
These points are not at all. It's better you avail your appropriate remedy. The challenge to this is not maintainable. Sir. You have to withdraw it with liberty to avail your whatever remedy available.
You got to do?
Avail your remedy available under the law, withdraw it and avail whatever remedy or grievance, if you have any, avail your remedy. This will not do.
The lordship may fix it another date. I have to
No, sir.
consult.
Another day. Today it's for a hearing and,
Then you also pass it outside.
okay, we'll pass it.
So it is not a case of occupied field lots, in my humble submission. Both are operating in different areas and there is no overlapping, no point of repugnancy at all.
If I can withdraw this petition, then we'll have what kind of
whatever the grievance, if you have any regarding your service conditions or whatever it may be, you may avail appropriate remedy available under the law. That could be the best. Okay.
Only thing is I want to have some instruction. That is,
You seek your instructions, we are giving you half an hour time. You seek your instructions. We'll wait for you. Call them immediately and seek your instructions.
Item 7 and 8.
Please, your lordships, my lord, in this matter, the it has been, the proposal has been, is going to be placed before the finance department. Well, the law department seeks some time.
Earlier, you have some, who is there for the finance department? What happened? We have sent you the proposal, sir.
There's a fresh proposal which is being placed, my lord, it's going to.
Yes, fresh proposal. We have also sent the copy to you. also.
Pursuant to that, they have raised some queries, and those queries have been addressed.
The registrar
Now,
general.
recent, I have a letter, Lordship, where they have raised the queries to the.
Registrar General, my lord, he has responded and it has gone now.
Earlier, you have some objections. And we have sent a new proposal. Now you have to accept it. You can't ignore the recommendation of the High Court.
Lordship, we have yet to officially receive the proposal because right, the.
Officially, we have already sent the copy to you also, sir.
The department has the complete proposal for the public letter along with the list of the proposal.
But letter dated
This High Court has sent the proposal to you and you are not in receipt of that?
Mr. Chalia, what about this fresh recommendation that was sent through the registry to the finance department?
Yes. That was
Sorry?
sent on.
Last time that's why only the matter was adjourned.
Yes.
Fifth of May, my lord. The letter from the registrar general is dated fifth of May, lord.
Only 5th of May.
Lordship.
You are in receipt of letter on 5th of May.
The letter from the registrar general is dated fifth of May, lordship.
March 24 two, I think. Communication is 27. What about the communication 24th February 2025 that was sent earlier?
That is the only proposal.
After that, the judicial department has raised some queries.
And the registrar general has responded, my lord, on the fifth.
Registrar General, what Registrar General has said? What he has said, he has only referred to the earlier order passed by this court. On 26/8/2022, you can,
Lord,
even though this matter is pending, you can very well take a decision on matter of clarity.
lordship,
They simply informed you.
lordship.
Not a letter, man. Well, please, take some excuses जो हजम हो सके. Don't take lame excuses. Since February, it is pending consideration. Finance department will look into it. How many years you will take for that?
Lordship grants a fixed time, my lord.
We have already granted you time on this last occasion, 1/5/2005. They granted you the time.
I understand. I just pray that a short time may be granted, my lord. Whatever is deemed appropriate by this honorable court.
It is sorry state of affairs that a fresh proposal sent by the Guwahati High Court on 24th of February 2025 to the Judicial Department as well as the Financial Department is not even considered by both the departments. And every time when the matter is listed, time is sought to complete the instructions. Full stop. Last opportunity is granted to the law as well as the finance department of the government of Assam to respond to the fresh proposal sent by the Guwahati High Court on 24th of February 2025. List on. Now take your own time. How much time? Last opportunity, thereafter we'll call the chief secretary and all the secretaries.
In that case, may I pray for 8 weeks? My lord?
How much?
6 weeks, my lord.
Ma'am, please try to be reasonable. Be reasonable, ma'am.
4 weeks, lordship.
Not at all. Be reasonable. 19th of May. Come with this, otherwise we'll call this chief secretary, law secretary and finance secretary. Right.
Lordship, would it be 28th of May, Lordship, will be hearing the Lord? Would it be 28th of May, Lordship? Will be a
19th.
Lordship.
19th.
Lordship.
Item number 9.
It's covered by the division bench judgment.
My lord, actually what happened, that impugned act which is put to challenge, my lord, that does not cover the situation which is here. In my case, my lord, our college is provincialized college. It is provincial in the year 2005. And our department, which has been established in the year 2004, and it is not provincialized along with that at that point of time. Now the act which has come, my lord, it does not include this provision. That's why, my lord, we are in the not been provincialized. There is a gap in the act itself. And in the meantime, my lord, the department has constituted a committee to examine the.
You just tell us one thing.
Yes.
You have prayed in the petition. What is your prayer in the petition? Whether this prayer can be granted?
My lord,
Whether this prayer can be granted?
my lord,
What is your prayer?
there is no.
Issue a direction to the authorities to amend the. Sir, how can we direct them to legislate or to not to legislate any laws?
In the meantime, my lord, that they have established on a committee, my lord, to constitute a committee. That
So
in
represent the committee.
in this committee, our case may be placed, my lord. That's much, my lord. Respondent number 1 may please, my lord, directed to place the matter before the committee.
You approach the government, they will place it before the authority is concerned. But how can we direct this? While exercising power under Article 226, how can we direct them to legislate a law?
Only to consider the case of the petitioner, my lord.
You can approach the government, will grant you the liberty to approach the government and then consider it. Otherwise, this 2017 act is validity is already upheld.
Validity
For all purposes.
that act, there is, we are only just looking the provision that he has, my lord. Our circum.
Together different.
Yes,
That is different.
that is, that your lordship may observe, my lord, and dispose of, my lord.
Learned concept for the by way of facility petition. The petitioners are seeking the following reliefs. Full stop. It is to be noticed that the validity of the Assam education in bracket provincialization of services of teachers and reorganization of educational institutions Act 2017 has already been upheld by the division bench of this court in Mehboob Ali, or what is the name of that? 2017 special bench. In Mohar Ali Sheikh and others, what's the state of Assam and others? Yeah, इसमें से होता है. So and so, so and so. Full stop. And then concept of the petitioner has submitted that since the validity of the Act of 2017 has already been upheld, he wants to withdraw this writ petition on instructions. However, seeks liberty for the petitioners to raise their grievance regarding non-inclusion of
The provision for provincialization of the department of a college.
non-inclusion of the Department of Colonization in
Non-inclusion,
the scheme of provincialization before the state government by filing appropriate representation. Full stop. When the concept of the respondent has no objection if such liberty is granted. In such circumstances, this petition is dismissed as withdrawn with liberty for the petitioners to move appropriate representation before the state government for ventilating their grievances,
before the cabinet subcommittee, my lord.
ventilating their grievances before ventilating their grievances, if any such representation is filed on behalf of the petitioners within a period of 1 week, 1 month from today, the state government shall consider the same or refer it to any committee formed by formed for for considering these matters and take a decision strictly in accordance with law expeditiously.
Yes, obliged, Mr.
Item number 10. Yeah, we file affidavit only if here the case of the petition is that his TDS detected by the department, but not not reflected in the his 26 AS.
26A, if it is not reliable, who is going to fill this 26AS?
No, Lordship, it is the
Form 26AS is to be filled by whom?
no, Lordship, it is automatic generated form, Lordship.
Automatic generated form by the department.
Yes, by the income tax department.
So if the TDS is already detected, and if it is not generated in your system,
No, Lordship, what
how this person is liable
no.
for that, sir?
petitioner is not responsible. Lordship, here what happened? The amount was deposited with the treasury without PAN number of the petitioner, Lordship. That's why it was not reflected. Lordship, after.
Now they have filed the affidavit.
No, Lordship, what happened? I approached the learned advocate, Registrar General, requested him to instruct the DDO to correct the put the PAN number of the petitioner in the website, in the net. But they refused to say that we have already
They have already done it. Now it is your headache, whether it is reflected in your system or not. We are not concerned. You are aware of the PAN number of the petitioner?
no, Lordship, but we cannot rectify that from 26 years. No.
He has already cut, this TDS has already been
Well,
deducted. Now you can't force it.
Section 205 is very clear, my lord, and there are various division and judgment of our High Court also.
Harass this person.
No, no,
Sir, हमारे system में आ नहीं रहा है तो पैसे तुम दो. Why?
If it corrected by the employer, then it will be reflected accordingly, everything will be solved, Lordship. But neither the Lokayuk nor our registry is doing all these things. Lord. And in paragraph, Lordship, paragraph.
Whatever it may be, you initiate proceedings against the Lokayuk or High Court, this person can't be arrested. Whatever you can do, you may do.
Lordship, page 86, our Lordship, page 86 our affidavit में kindly refer to.
Your affidavit and look into their affidavit.
Yes, I have gone through their affidavit, Lordship.
They have said that we have already deducted
But Lordship, our contention is that only PAN
Sir,
number is the
whatever it may be, you may take action against the Lokayuk or this High Court, whatever you want, how this person is liable for that.
we are not holding responsibility the petitioner Lord.
That's why only he approached this court,
No, no, no.
otherwise इसको क्यों
No, we
सोचना
have-
रहता है, क्यों आता है यहाँ?
We have clarified in our affidavit Lordship. Lordship, please to just for my satisfaction, Lordship, page 86 Lordship.
Will read, read. Yes,
Page 86 Lordship.
86. Yeah,
It is pertinent to mention here that the onus on the deposition of the income tax related source lies with the employer.
86.
86. Just
Okay.
part of paragraph 4 Lord. The affidavit filed by one Priyanka Sharma Lord. The deputy
Priyanka
commissioner,
Sharma.
No.
Yeah,
page 86 Lord.
86 पैरा कौन सा है?
Paragraph 4. The part of paragraph 4.
Paragraph 4. Read. That with regard to the statement,
That with regard to the statement made in paragraph 3 of the writ petition.
it is page 78. है. Yeah,
The answering respondent state that on perusal of the writ petition, it is seen that for the financial year 2008-9, 13-14, the advance tax deducted source of the petitioner, Sri so-and-so, is not reflected in Form 26 AS due to non-credit of TDS in the 26 AS. The demand of these years is outstanding. The petitioner in para 3 of the has mentioned that during the aforesaid period, he was serving as judge of the Honorable Guwahati High Court in Lokayuk of Upper Lokayuk. He has also stated here that the advance tax deducted source is not reflected in 26 years of the SEC due to inheritance of the respective employer. The next paragraph. It is pertinent to mention here that the onus of the deposition of the income tax deducted source lies with the employer. After the employer has deducted the income tax at source, it has to be deposited against the respective PAN only. Only thereafter the TDS credit is available in 26 years of the deductee. It appears that this exercise of deducting tax at source and subsequent deposition of TDS has not been correctly done by the employer. This led to the creation of outstanding demand against the petitioner. So our case is limited, Lordship, if it is corrected on the,
take action against the employer. Why against this person?
no, Lordship, for sorting out the issue, both the employer can be directed, they can, if they put the PAN number,
Sorry,
then it will be, problem will be solved, Lord.
sorry, sir.
The Lordship, necessary direction is
To whom?
to the income tax department.
Necessary direction, you go and ask them. Not, this court will not direct you.
And we have clarified our position, Lordship, as paragraph.
You have clarified, but how, in view of section 205, how can you ask the demand for that?
No, Lordship, because it is not, the amount deducted at source is not reflected in Form 26 years.
नहीं होगा, sir. How you, section 205 says, if it is deducted,
And the tax
deducted, there is no
is-
condition that it has to be reflected or something else.
Shall not be called upon to pay the tax himself to the SSC to which he has been deducted from that income.
There is same thing, division bench judgment also, my lord, where petitioner is there, my lord, judge, my lord, Queenie judge, along with the Chief Justice. And there are other judgments also of Bombay High Court. And yes, it will be.
In the Jiri Chalan, PN number has not been mentioned. Lord.
See this, whatever the PM number is mentioned or not, you go and take whatever you want, but not, you can't arrest this person, that's all. So one of the member of the division bench is Justice D. Viswas. इसी वजह से इनके खिलाफ में चालू हो गया, इन्होंने जजमेंट आपके खिलाफ में दिया तो. This is too much.
No, other judgments I have. Other judgments I have. Delhi and Bombay. Same. This para 12.
That's all. Close for orders.
October item 6. I contacted him, like he told me that it will be difficult on his part to give any. I contacted General Secretary, and he told me that without holding any meeting, it will be difficult. So your lordship pass any appropriate order as you give it, because I should not concede.
Then no liberty, we can't grant you.
That will be a problem. I told him It is very difficult on my part to give the consent. And he is also correct.
Is, okay, 14th?
Oh.
14th May.
Yes, that will be better.
The
For-
council,
Let it be 17, Milord.
17th.
17, I am not, 14th.
All right. So he's,
You have to seek instructions, otherwise we have already heard the matter.
yes, yes.
The, by this petition, the petitioner has challenged the validity of the Assam Inland Water Transport Regulatory Authority Act 2018, precisely the validity of section 14 in bracket 1, again in bracket K of the Act of 2018, full stop. Having heard the learned counsel for the petitioner as well as the respondent at length, we are of the view that the challenge to the Act of 2000, the challenge to the Act of 2018, and particularly section 14(1)(k) of the Act of 2018 is without any merit. However, at this stage, learned counsel for the petitioner prays some time to complete his instructions. Full stop. List on 17th,
The 17 is a Saturday, Lordship.
14th of
14th.
May. You complete your instructions on 14th.
Oh, yeah, I could.
14th. So,